I'm gonna preface this before we jump into this. Something I found, I talk a lot about my time at Microsoft, and I was there as a Windows support engineer and network support engineer, and then I spent 13 years doing incident response. And one of the things that looking back that always strikes me is how much, as soon as you jump into cybersecurity, you're likely to interact with lawyers in the law. So before I became an incident responder at Microsoft, I talked to exactly one lawyer in the legal department at Microsoft. And the only reason that happened is because he had a very similar email address. He was Neil Calvin, I was Neil Carpenter. And somebody accidentally sent me a whole thread right in the middle of the Microsoft antitrust lawsuit that they meant to go to
Mm.
Neil Calvin. So I got a very alarming message. That was it. After I became an incident responder, I talked to legal probably every week, every other week for 13 years. Um, and had a ton of interactions. So, just generally speaking, I think it's a great conversation for us to have. More importantly, AI is obviously sort of not sort of, it is a hot topic these days. And I think that there is a lot of confusion and a lot of unsettled um, stuff there. So, Jay, I will let Jay give you a fuller read on his background, but Jay has a tremendous background in technology. He is one of us who has become a lawyer who is focused on technology and the law and is now building a law practice specific to artificial intelligence. And he's kind enough to join us and talk through what the state of things is and what he thinks we need to know, and then answer questions. So that's enough of me talking, Jay. Let me shut up and let you jump in here.
Sure, and thank you. Thanks everyone for taking the time out of your day on a Friday morning to listen to me. I'll try and be really careful to reserve time so that there's plenty of opportunity for questions. I take it you all can hear me okay? Great. Uh, so here's a bit of background that's a little bit less formal. It's better in some ways to be lucky than smart, and I've had some good fortune in my career in that when I first started as a lawyer for corporations, uh, I worked for a company called VA Linux Systems, and it was, along with Red Hat, one of the earlier companies to adopt Linux in a commercial context. As some of you know, it was loading Linux onto Intel-based servers, and it was used to build some of the early backbone for what we think of today as the modern web. And it had its challenges, but one of the really wonderful things about that company, and I think Red Hat probably had this as well at the time, the people who built Linux and all the libraries that kind of went with it, they needed a job, and that time period afforded these people a job where they got to work together. And my background is computer science, and I went into law with technology as kind of my ultimate goal. And I got to work with people who, this will sound impossible, but trust me, there's a lot of truth to it. People who built the front end to YouTube, the front end to Gmail, the improved how rapidly Google returned its search results, who kind of built the early back end to Google, the person who built the infrastructure for Google, the person who was overseeing the creation of PHP that ultimately was used to write Facebook. So I worked with these people, the people who did the databases for LinkedIn, the search engine for LinkedIn. So my day job was to interact with these very deeply technical people, and it was incredibly helpful for me. So the one thing, to echo what Neil said, is if in the course of your work you encounter a lawyer with some varying degree of technical understanding, it's great if you can establish those relationships, because you never know when there'll be something urgent that comes along. The other reason why it's really helpful, and I think it's exactly what this presentation is about, is contracts and regulation have a lot of influence on cybersecurity. And a lot of times a contract will get executed. The lawyer and maybe the business people will have a lot of time with it. It's unclear to me how much time the cybersecurity folks get with these agreements, and the area where it comes in is the exchange of data. Obviously, in the U.S. now, there's a couple dozen state level privacy laws, and all of these laws govern how personal data is processed. And for a lot of us who work at companies, unless you're in the legal department or you were the BD person who did the deal, the odds that you know exactly what everyone had in mind when they entered into those deals is low. And then the odds that you were there when the privacy notice was created that said how data would be processed, for what purposes, who it would be shared with, and for what purposes, yay, if that actually is a part of the process at your company, and it should be, and the laws would say that it has to be. But my experience is that there's not as much communication as there should be, and Neil's experience certainly echoed that when he started off today's conversation. So what I have today is a series of regulatory matters. I won't spend too much time on it, but I'll show you kind of examples of recent regulations in Europe and in the States, both at the federal level and at the state level, that sort of touch upon these themes. So we've got increasingly complex regulatory frameworks, and these frameworks are adapting to very rapid change. I've been around technology for a couple of decades. Different things that get a lot of attention, I think, are sort of to varying degrees real. Working closely with AI, I think if anything, it's more real than people are imagining, and the pace of change is incredible. And I know there'll be periods where the pace of change isn't as rapid as maybe it is right now, but it's pretty incredible. And I think the law will have trouble staying up to pace, and maybe engineering and your groups will as well. Uh, I'll talk a little bit about synthetic data today, because there's a lot of money changing hands around this, and I think it's not well understood that synthetic data has underpinnings in real world data, and as a result, can touch upon privacy regulation, cybersecurity, information security, et cetera. Um, the privacy enforcement cases were, I'll take you, I guess, a little bit to law school today, but it's more about just seeing the kinds of things that are getting regulatory attention. So why data is processed is emerging as a key consideration. It used to be that access management was the focus, and also just am I giving consent to company A, sort of yes or no. And you'll see in one of these cases that the company that was under scrutiny kind of said that, hey, we got consent, and that ended up not being sufficient. So I think if you want to apply a more modern lens, it's the purpose of processing, the purpose of sharing. Why are you doing this? Consumers need to be told this. Contracts that reflect exchange of data need to reflect the why aspect. I put citations in here. Um, Feel free to reach out to me if you need any, if you have any questions. I think it's really important for people to know that whenever a law passes that relates to privacy or information security, whatever the body is that's tasked with enforcing it will then create regulations explaining how they interpret the law. So a lot of times there can be multiple documents that you have to reference to understand what the requirements are. So again, if you can make a pal or two who are lawyers, they can help you kind of sift through that. And feel free. I'm a more informal lawyer than most, so it's okay to reach out to me. And if you don't have my contact information, I'm sure someone, probably Neil, could give it to you. Uh, so Grinder. This is an interesting one to start with, because the The EU did a really good job in their findings of writing something that's actually human readable. I took a look at it again this morning, and if you're ever going to want to delve into being a lawyer, it's not a bad starting place. So the Norwegian Data Protection Authority, when they issued their findings, wrote something that I find, and I read a lot of lawyer stuff, so maybe I'm not the best judge, but I find it to be pretty readable. So the context here is for programmatic advertising. There was a lot of information being transmitted in the bid request, and the conclusion of the regulatory body was that the consent that had been given by users of Grindr did not have sufficient granularity to provide permission to disclose sensitive user data like sexual orientation. And so the penalty is actually somewhat modest, but I think there was a lot of enforcement component to this. So it's a lot of times the headline is company X was fined some number of millions of dollars, and those numbers have trended up over time. What sometimes doesn't get as much attention is the compliance aspect of it. A company that I know really well, but I won't cite them, got got into regulatory proceeding because they had a sort of pure heart and empty mind problem where they had come up with a clever way to advertise in a context that wasn't well addressed, and they were trying to sort of help everybody meet certain guardrails. And you could think of it like this. I can't get into detail because it's a client, but um, they ended up in a regulatory proceeding because their tech didn't work as well as they had said. So they were trying to help their business partners be compliant, but they didn't do it as well as they could have. And as a result, even though they were actually trying to be compliant, their failure to actually execute on that ended up with an enforcement. And here, Grindr was trying to make sure that they got consent. They just didn't do it in a granular enough way. Where that affects cybersecurity professionals is once that data is ingested, understanding the pedigree of the data is really important because it can flow all throughout the company. And obviously now with AI, if that data is used for training, if it's used to create derivatives, it can become the cybersecurity professionals problem, and the system operations people and all the people who are trying to manage data, because that data can get everywhere. So some of you may have heard about this one, but facial recognition AI training using consumer photos, and this one is a U.S. enforcement action where um, the Federal Trade Commission said that there were unfair and deceptive practices. Basically, consumers are using a tool for their consumer photos, and it turns out that those photos are actually being repurposed for facial recognition AI. Um, the takeaway here is within reason, companies can do these kinds of things as long as they explain in a transparent way what they're doing so that a consumer can understand the benefit of the bargain. And I think in this instance, that absolutely didn't happen. And as a result, um, they the FTC said that the data was misused in the context of AI and synthetic data. So uh, here's another case study, and I know I'm moving quickly, but I think it gives us time. So here, a cloud provider retained and exposed vast amounts of data, um, and the safeguards around segmentation, and I think that'll be the theme for almost the rest of this conversation, need to be in place. Otherwise, there's a risk of basically polluting all your data sets. And um, in that, in the first two proceedings that I just covered, one of the remedies was to go and delete data sets. And so for teams that are responsible for logical segmentation of data, understand that the consequence, if it's not done in a well-documented way and in a thoughtful way, regulators will come in and just say, purge it, start over. Amazon Alexa, in the children's privacy context, retention of voice recordings for AI training beyond the consent period was the issue here. Having had the pleasure of working with engineers for many years, it's incredibly difficult to get engineers to part with data, particularly part with it in a pure way where there's no archival. It's extremely important to understand data retention obligations and to honor them. And if there's a departure, to kind of raise it up the flagpole so that business people can understand the business risk associated with retention. So Sephora has wonderful brand recognition. I have no doubt an excellent company. This is a pretty big miss. So here they put the process in place for consumers to say do not sell data, and then they didn't honor those do not sell signals. And so I think, again, for the cybersecurity professionals, I think it's important that you raise the alarms if there's circumstances where you have question about whether uh, the that there's a workflow that aligns with what customers are being led to believe is occurring. So here, that simply didn't happen. Customers did have a mechanism for saying, don't share or sell my personal data. It just wasn't resulting in any action. This one, if memory serves, is a bit creepy. So this is internal misuse of video feeds by employees for inappropriate monitoring. And I think here it's very clear that purpose restrictions are super important. And then for employees who have access, and certainly ones who have root access, um, they have to make sure that they're aligning that access with the purposes for which the data was provided. And that could be consent from a consumer, that could be your business partner, because a lot of times data is ingested. I started, as we talked about at the beginning, in the Linux space. I spent about 6 years in automotive. I worked for a company called Cox Automotive in Atlanta, Georgia, and I had no idea how data intensive the automobile industry is. And if you sort of think about it, you've got credit agencies, banks, all the dealerships, and some of these groups are enormous, something like AutoNation or Penske. The amount of data flowing between these entities is incredible. And that's just if you think about it, data relating to a person. Then you've got all the data relating to the vehicle and where it's located, um, whether it's adhering to law, whether it's driving erratically. If you're State Farm, you might want to know that a vehicle drives erratically every Friday night, because that might be indicia of somebody who drinks and drives. So in this instance here, the misuse did not get reined in by internal policies that were aligned with the purpose restrictions on the data. I think this is the last case study. So this one, using consumer financial data to create derivatives. This is actively under review, and this is one where it is creation of synthetics and derivatives of data, and we can talk about it in the Q&A if those concepts are clear. And what you want to know there is a lot of times data can be very closely aligned with a person, and as you create derivatives of that data, it gets harder and harder to go back and re-identify the person. And where it looks like this case is going to go is that, given that the kind of base data was people's personal information, the derivatives, the data sets that are based on the original set are also required to align with the purpose limitations that the data was originally um, received with, either from a consumer consent or from a third-party business partner. All right, so a little less on the law side, but um, so synthetic data is, it's important to kind of make sure we all know what that is. I imagine a lot of you, if not all of you, do. But it's actually generating a lot of money for companies. You can take a data set that sort of has a real world basis and leverage that data set to create lookalike data sets that can be valuable to business partners or to other parts of an organization. And the problem for lawyers is these concepts didn't didn't really exist until recently, and certainly as the synthetic data leverages AI, you get more and more sophisticated ways to create new data sets, and so the law is trying to kind of keep pace with this. The short takeaway is that if you're at a company and the company is monetizing synthetic data or making good use of synthetic data, it's important to understand that the the rights that are the rights and obligations that are in the contracts, the rights and obligations under law, the rights and obligations that come from consumer consent, all of those have to be honored in the course of that process, and where that data is ultimately being used. So this is the reason, kind of right here. I don't know if my cursor shows on your screen, but um, identify identifiable attributes in the data can enable potential re-identification, even if that's hard today. Given the pace of AI and the incredible advancements, I think that regulators are understanding increasingly that with those advancements, the sophistication of compute technology is such that synthetic data can can likely be used to re-identify. And as some of you may know, companies like LiveRamp and others over the years have helped sort of align personally identifying data with personal data that maybe doesn't expressly identify someone. And I think with AI, that's going to actually become more feasible. Oh, it'll become feasible in circumstances where it's not been feasible historically. So some recommendations. I think metadata is extremely important. There's a lot of companies that do a good job of helping with that, but understanding where purpose can be introduced into the metadata, and then making sure that that purpose kind of flows with the data is very important. And then having a process component, like a pre-deployment review, to make sure that before something goes live, people understand the flow and the kind of pedigree of the data, and then making sure that the lawyers are aware when uses change or expand, so that privacy notices can be updated. And then, by the way, DPA just means data processing agreement. It's a European specific term, but same kind of idea. It's usually an agreement that's put in place between parties that are transmitting data, and usually it's when someone's processing data on behalf of someone else. So we talked about classifying and tagging data sets, segregating repositories to ensure consistency around purpose, pre-flight validation, documenting lineage. However hard these tasks are, sort of unscrambling the egg is always harder. And that's it. I need to go through my bio. So that was what I came with for prepared remarks, and I'm really open to questions that you may have, and to things that I might not have been clear about. And I hope there was some value in some of that communication.
Jay, and I think there's a ton of value speaking for everybody, but mostly speaking for me. I'm going to jump in and sort of take the privilege of asking the first question. I'm not sure I'm clear on synthetic and derivative data. Like I
Sure.
sort of know what you mean, but it would be great if you could give a couple of examples of what that would look like.
Absolutely. So um, let's talk about derivative because it's the historical one. So if you have, um, if you're a book reader and you read Huckleberry Finn years ago, um, there's a new book, and I'll confess I haven't read it yet, but I've heard good things about it, called James, and it's a book that takes a very different look at that historical context, and it's the character in the original Huckleberry Finn. uh Jim is James and the subject of this book. And so for lawyers, the vernacular would be that book James is a derivative. It's based on the other book. And so a lot of the data sets that we interact with in the tech space are derived, maybe they're from multiple data sets. So you get an example could be audience extension. So in digital programmatic advertising, you might say, oh, I need to reach 500,000 California consumers. And I have a data set that the company has, the first party data, that maybe is 80,000. And so I need to partner with Axiom or one of these companies that has data and extend my audience by another 420,000. And you can give characteristics of the original data set to get lookalike. Um, and so if you think about, if you're using your phone has a IPv6 address. It has, if you're on an app, that app has a bundle ID that says what the app is. The app has you can also see what the build is for that app. So there's a bunch of things that you can start to do. The device identifier, either if it's an identifier that's specifically to be used for advertising, or it's a identifier that's more kind of tied to the hardware of the device. There's all these kinds of things that could be discrete data elements associated with this data that you could use to target a consumer, maybe with advertising. And uh, what's interesting about the last few years is that it's turned out that if you have that starting data set, you can leverage AI and machine learning to create synthetic data sets that are based on that data set. And so it used to be you'd have to kind of go out and say, well, give me all of the things that have similarity to this data set. Like, for example, the geo IP address shows a geographic a latitude and longitude that's similar. And so that will get you other consumers that might be in Pasadena, California. Synthetic data is a way to leverage AI to create data sets based on real world data. And there's lots of uses of those data sets. And as AI gets more sophisticated, um, it can be extremely valuable to data intensive companies to be able to create these data sets. But they do need training data. They do need data to ingest. And the problem there is that it's like the telephone game where the person who gets tasked to do this work, unless that person is asking, well, where did this data come from? Where, what kinds of rights, how was it obtained? Was it obtained from consumers? And what was the context in which those consumers provided that data? Did you get consent? Um, the other overlay that's in all of this is geography can be a major factor. So if these are California consumers, the California Privacy Protection Act will apply. That's changed quite a bit in the last couple of years because there was a California proposition called the California Privacy Rights Act. So if the data pertains to consumers in California, or the original data was pertaining to California consumers, it's very likely that the California laws will apply. Similarly, there's laws in Virginia, Colorado, Utah, lots of other states, and so derivative works based on that original data will likely have these regulatory obligations. They'll have contractual obligations that probably flow. Similarly, now data that's um, based on the original data set but generated by AI, uh, a lot of times people think, well, that's a new data set. That's the AI created that. But if the training data clearly was a kind of large factor in the creation of that data, um, odds are that the original contractual obligations or the scope of consent will apply, and that's what I'm trying to get at that point. And I think the best way to avoid that risk is logical separation of data based on purpose, or if that's not feasible, some metadata, something that everyone knows is the way in which you characterize the data based on purpose. And so purpose could be to use my app or to improve the app. But sometimes purpose can expand to provide me with advertising opportunities about products that the company thinks might be of interest to me, or products from their business partners that might be of interest to me. And that's where um, it gets interesting, is if that element wasn't there, it wasn't in the contract or it wasn't in the consent, if that data gets generated for the purpose of doing digital advertising or something like that, and that was lacking, it it's pretty likely that you'd lose an enforcement action. Doesn't mean that there'll be an enforcement action, but it'd just be, and then you have all these consequences, like data has to be purged, or you have to go and find the discrete data elements that were derived. And that's really hard in the AI context, because sometimes it's hard to just decipher what an AI used to generate its data.
Awesome. All right, questions. Raise your hand if you've got a question for Jay.
I have a question for Jay. So there's a lot happening with AI regulation, and there's like proposed uh, uh, restrictions against new AI regulations in the big beautiful bill. But I have two questions. So one's about that, and the second is you mentioned, derivative usage, and it immediately makes me think about Reddit selling all the data off to AI to be processed. Like, does that put them in a bad position because, the people using Reddit had never had that expectation?
So I'll start with the last question. It's a great question, and I can tell you, and that's and this is probably the best example of synthetic data right there. I mean, that data set is incredibly valuable to use for training data. And so I started my career, as I said earlier, at VA Linux. One of the things that VA Linux owned was Slashdot. And for those of you who are a little bit further into your career, you know that Slashdot, and then Dig, and then there was a kind of progression of these these tools that enabled, usually it was the technical people, to have conversations about topics that just weren't that didn't have a good setting for conversation. And like, this is a great example of the kind of thing that solves that problem. But Slashdot did as well. It was a kind of digital water cooler, and that data set, similarly, if you look back at that historical time, the people who were communicating on that were people who were building what was then the modern web, and now is kind of the ancient web. Similarly, Reddit, there's because it can get so granular in its topics, it's an essential training data set for certain types of AI use cases. And the question that it begs is, when somebody, if Linus Torvalds went to Reddit and started to talk about Git years ago, and before Git existed, and vent his frustration about source control and et cetera, um, did he realize that all of those communications could be repurposed in all of these ways? And um, is it fair? Lawyers would ask that question: is it fair um, to use the data in this other way? And by the way, I think the trend in the US is the answer is going to be yes. I think that's kind of where we're headed. So it's exactly the right question, and I think for the cybersecurity folks, the hope is that the lawyers and the business people will have had the forethought to get these rights and these consents. It's so hard to do that when these technologies didn't exist. They were let me just take a little drink of water so I don't lose my voice. Sorry. So I think, to answer your question, the first question, I suspect there's going to be preemption. A lot of people who supported the current administration are going to be strong advocates of one um, U.S. policy, for better or worse. I think that's likely where things will go, and I think it's probably enforceable. So I think there probably will be the opportunity for a federal law that says this is the regulation. This is the law that applies to AI, and anything that conflicts with this is superseded by this. And then, in the context of consumer data that's getting repurposed, I think in the US, generally speaking, it's going to be permissible, but I think it comes down to reasonableness. And this is where, like, using children's voices to train Alexa related AI is a bridge too far. So, oh, that's funny. I don't know if you heard that, but I said Alexa, and my unit just asked me what it wanted, and it's actually the new version, so it's asked me in a sophisticated way. So yes, I think paying attention to the developments around AI regulation is important. I do think there'll be a federal regulation. I think it's very important to understand that data flows transnationally, and that there's all these other regulations worldwide that are coming. Obviously, EU is farthest along and now has the EU AI Act. So it's worth paying attention. It's worth making sure that the business people are thinking about use cases, and then when you get tasked with doing something, it's worth having the conversation about, hey, where do we derive these rights? Like, what specifically are we permitted to do with this data? And that way you can make sure that as the data flows and as derivatives are created of that data, there's a tie to the original purpose.
Jay, I see your hand up. I guess. Jay, you on
Yes,
mute?
like maniacally trying to find the mute button and that kind of stuff. Hey, Jay, really good
Hello.
to meet you. First of all,
Likewise.
doing God's work, it seems like a lot of the functions that you provide is what our cyber legal team does in SAP, which is literally also there to connect between the technical and the cyber people, and now also our AI people, data privacy, and corporate counsel, who are, let's say, not necessarily particularly technical, but know how to read contracts. My question to you is, like I see you have a 415 number, and of course, if you're coming from Europe, certain things are quite normal. I myself also in the Valley, and I've found that a lot of my peers often are quite surprised when certain regulation comes up. You had a GDPR use case, and I remember like in a January before that went into effect, we had been working on that for already a year and a half to be ready. And I asked my peers, like, hey, what are you guys doing around GDPR? And the reply was, what's GDPR? So I just want to ask your experience, like specifically from the Valley, like how much understanding is there even that there are laws? And like, even if it's not US or state law, that they may have on their radar that the moment they extend their service internationally, that things get a lot more complex.
It's a great question, and I had a couple of my employers have had pretty significant presence in Europe, and so I kind of got force fed the vernacular of European data protection law, and to a certain degree, the new laws, kind of with the exception of California, which is its own thing, but a lot of the new U.S. state laws adopt a lot of the nomenclature, a lot of the terminology is the right word, from the GDPR, and I actually think that that's helped. So as companies here, I also think there was kind of a tipping point where when there were like 4 US state comprehensive privacy laws, people sort of started paying attention. And then when California law was amended by the California proposition, and a bunch of the things that were pretty significant loopholes in the first go around got addressed. Some of those were not really loopholes. They were lawyers who were sort of squinting and pretending there were loopholes. There was some amount of attention. I don't think it was the level of attention that was present in 2018 as GDPR became effective. I think Europe was very much taking that seriously. I don't think that happened as much with the first 4 laws here. And when I say the first, like Utah, Virginia, Connecticut, Colorado, so I guess there's 5, and California, when those sort of came into effect, I thought there'd be something like what happened in May of 2018, where everybody was really like grinding to be sure they were compliant. There wasn't as much of that. To some degree, that was because the California Privacy Rights Act, the regulations that came into place were delayed because a court, a kind of intermediate court, said, "Oh no, it has to be a year from the date that you published a regulation." So there was a little bit of a grace period. But even after the grace period expired, and actually a higher court reversed that, but there still wasn't the seriousness that I think to this day persists in Europe. That said, most of the state laws adopt terminology of EU. There is a lot of activity around enforcement. Colorado has kind of taken up the charge around automated decision making and AI. So it's not all California at this point. And then there's going to be continued enforcement at the state level. I think I don't know that that's the case with the FTC. Obviously, the FTC under the Biden administration was more proactive in this area. I don't know where we're going to land under the new administration. Obviously, it's a
I'm
very,
not a
very different.
lawyer, so I can say nowhere.
Yeah, I mean that's my guess. That's my guess too. Um, but I do think the benefits are harmonized. A lot of the U.S. laws harmonized with EU terminology, and a lot of the concepts like bundling consent. I mean, like I said earlier, I really do think for people who are trying to understand the GDPR, if I were to just give somebody a primer, aside from just reading the GDPR, which actually is not that hard to read, um, the Grinder ruling by the Norwegian Data Protection Authority, just whoever wrote that, just really, I mean, I've read obviously the English translation, but it's very readable. And then I guess now with AI, you can just ask Claude or ChatGPT to just give you a primer on each of these laws. I mean, it's really fantastic. I mean, it might give you something harebrained, but increasingly
Yeah,
that
lot
doesn't
of
happen.
EU regulation is based on principle, right? Which makes it far easier to understand than like, have a whole bunch of rules that like judge how you have to do certain things. So that makes it much easier also, I think, to come to conclusions whether you've violated something
Jay,
or not.
yeah, you just reminded me of something that is the key takeaway for me. Um, and it's absolutely aligned with what you just said. So if you look at everything in Europe, it's tied to a data subject, and the principles, like you said, they're about freedom
Yeah, it's all
and
about
freedom.
the integrity of the individual
Yes,
citizen person.
the phrasing in the U.S. laws often uses the term consumer, and yeah, I know. It's so funny because I read, just to give some of you a context, I was working on an AI project before this law firm. I worked on an AI project where I was digesting all of the world's privacy policies and then using AI to kind of render compliance opinions. And I had to read all these laws, and I read them and read them and read them. And some of these things are hundreds of pages. The regulations are really long. And well into that, months into that, it dawned on me that everything is, the phrase is consumer. So I do think that that probably is the most telling difference between the US and Europe. Is Europe is really focused on fundamental rights, and the US is more wrapped in as a consumer protection vehicle. So um, I think what will be interesting to see too is, where does Asia land? Where does South America land? Where does Africa land? Like, there are laws in many, I mean, Middle East, many of these jurisdictions. It's just not clear yet exactly the degree of enforcement. I mean, China, uh, India. So I think we do have to kind of keep paying attention, particularly for those of you who work in global settings. Understand where the data is being processed. I hear lots of stories of, well, when we originally spec this out, it was going to be processed and stored in this region, but we got a deal and now some of the data is over here. So it's important to communicate and to understand like where data really is and what the data flows are. So
Awesome. Thank you.
yeah, thank you. And thanks for that question. It's great.
Any last questions?
I have one more. So and this one is just such a gray area to me. Um, so a lot of companies now, like, pick a big, managed detection and response company, or some type of security company, right? They're collecting a lot of telemetry that
Yeah.
is very sensitive data, I would call it. But part of the value proposition is using that telemetry, processing it with AI, and trying to figure out if there are um, things going on across boundaries that include, tenants, customers of that one service. Um, and so, like, really, at the end of the day, their very, very sensitive data is being used to create a derivative product, which theoretically is only used to help the rest of the customers, with the ultimate goal of providing a good defense, right? Um, is that a problem? Like with AI, like how do you protect that?
So I love that that's the last question. I couldn't agree more. So I'll get on my lawyer high horse. A lot of contracts don't have very precise definitions and don't spell out precisely what can be done with data and what can't. And I do think, hearkening back to Neil's first comment, if you have, and actually what Jay said too, you have lawyers at your company who have some amount of experience working with technical people, or they have a technology background, they can be so beneficial because the consequences are so hard to understand right now that you really do need a technical person. It doesn't have to be me, there's plenty of them, but a lawyer who's understanding that, exactly what you said. I am amazed at the relationships and the insights that AI today can generate. Like right now, we just look at the current state of AI, is really hard for a human to come close to insights that an AI can generate. And it takes, a lot of times it takes very, very bright humans a lot of time to understand how the insight was determined. Like it's non-trivial for really, really capable human beings to go back and figure out how the AI reached that conclusion. A lot of times they are right. It's just hard to find out how. So I think your question raises one of the biggest challenges that's going to be keeping lawyers like me busy, is how can parties, even sophisticated parties, enter into agreements? How can companies, even with the best of intentions, get consumer consent if it's incredibly difficult to understand how data can be repurposed? Going back to automotive, and then I want to be respectful of the time. Um, accelerometers. So modern vehicles have all this data. If your Allstate or State Farm is getting the accelerometer, I mean, your phone has accelerometers. So really, it doesn't even, you don't, if your phone can figure out it's in a car because it's connected to AirPlay, the accelerometer in your phone can say whether you're an aggressive driver, or whether you have to do panic stops, or any of the kind, or you're an erratic driver at certain times of the week. So the honest answer is, there are some things that I think can be done, which is very precise contracts, um, regulatory enforcement that has English language rulings. I mean, if I read an FTC ruling, and it was so, like, 20 pages in, there was no substance to it. And I think that was intentional to kind of be kind to the party, but it's exhausting to read. I think if we can get into a paradigm where stuff is written in English so people can understand it, it doesn't have to be a lawyer that's an intermediary, that would help. And then I think, honestly, contracts are going to be written in a way that imagine that the parties can't imagine all the uses. And so I'll leave you with this. Some big companies fixate on who owns data. Lawyers look at it and say, I don't care who owns it. I need to say what each party's rights are. So you can own it as long as I have all the rights I need. It makes you happy. And I think contracts are going to do the same thing. There's going to be this, like, here's the very specific things you're allowed to do. Everything else, I retain the right to. And I think that's going to be how they protect against the risk that you can do these things and nothing else. And I think that's probably how they're going to protect against what you're describing, because I think it's spot on.
But I got to say, first of all, great session. But if they wrote those in plain English that everybody could understand, wouldn't that sort of threaten half the lawyers in the country?
So I'll leave everyone with this, and Cyber, just thank you. There's this product called Spellbound, and it goes in Word, and it's using Claude. It's using Anthropic Claude. And as you're writing agreements in a right column, it's suggesting better ways to do things. Every once in a while, it suggests something stupid that I hate, but for the most part, it's so good. It's so good. It does such a good job. So I think lawyers are lawyers and accountants and lots of other professionals are already feeling that, and frankly, people who write code too. So
Yeah.
thanks everyone. I hope there was some things in there useful, and that's my email address if there's any questions.
Thank
Awesome,
you so
Jay.
much, Jay.
My
I'm going to
pleasure.
stop the recording and hand it back to Neil. Here we go.